if I tried to summon all of the necessary energy that I would need to explain to you how stupid that is. It's so dumb. The Darrell Brooks trial has been all over social media. And if you haven't seen any of it, if you haven't watched it, that's great. Because neither have I. Because I really don't have a lot of time for idiotic. Nevertheless, the internet demands, and I submit to these demands, to watch the top 5 moments that Darrell Brooks thought he knew what he was doing in court, but he had no idea. It is a law in America that you can represent yourself in court. You know, you can also perform surgery on yourself. People. There's some old adage, I don't know where it comes from, that says, he who represents himself has a fool for a client. I'm just saying. I don't know. That's been around for a while. Don't know what it means. Don't know if it's applicable to this video, because I haven't seen it, because this is a blind react. I have a feeling we're going to see that old aphorism is true. Shall we jump into the video?
You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people?
You're assuming they spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
So we're jumping right in the middle of this, and the first thing that we're hearing is that he doesn't understand that attorneys can talk to witnesses before they testify in trial. Guess what? You can. And only a fool of a lawyer puts witnesses on the witness stand without finding out what their testimony is going to be. Now, there are different gradations of this. You can find out what they think they're going to testify to. If they are your client, you might talk to them about what's important in the case and the points that they need to make. And if they are your client and also a witness, that's totally legal. And no one on the other side of the case, nor the judge, can ask the witness, like, what did you and your lawyer talk about? Or how did you get ready? What were the questions? What were the ideas? What did she say? What did you say? That's totally off limits because of a principle that you're all aware of called, say it all together, attorney-client privilege. You know it. Now, there is not attorney-witness privilege if the witness is not the client of the lawyer. So, if just using a classic example of an auto accident, if 2 people are riding in a car and one is hurt and has a claim in court and the other one is somehow not injured, that second person, if they're called to the stand and the lawyer has prepared them for their testimony, there is no confidentiality. So one of the lines of questioning that the witness is going to get is, how did you prepare for trial? Did you meet with this lawyer? If yes, what did they ask you about? And you have to tell the truth about that. Darrell Brooks is challenging the prosecutor's ability to preview the witness testimony in this case. That's not how it works. Now, I told you there were gradations. There is a type of witness prep that is colloquially known among lawyers as woodshedding. I believe, and I'm not sure because I don't beat my kids.
Ooh, I can't say that on YouTube. But I don't beat him, so I should be able to do that.
The woodshedding has to do about taking somebody out to the woodshed and spanking them with a stick. Basically, like, I'm telling you what you have to say and what you can't say. It literally is like a spanking metaphor. And every lawyer and every judge knows about woodshedding. Like, people actually say, as they're getting ready for trial, like,
let's make sure we properly woodshed our witness.
Anyways, maybe Darrell Brooks doesn't want woodshedding to be legal, but it is. Let's get back into this thing.
Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Can we address subject matter jurisdiction? It still has to be proven for the record?
I decline to do so.
Is that including verified proof that you have subject matter jurisdiction? Because it has yet to be verified or proven.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get a written decision. That's how I'm addressing this. And then I'm going to have the jury brought out and just providing courtesy copies to the parties as I had an opportunity to finalize that over the break.
Set for value and return for value is document.
Thank you for noting that. All right, bring the jury out. State has its next witness, I presume, ready to go? All right. When the jury's brought out, you may call the witness.
So the first mistake that he makes once we get into the trial is that he's either challenging that the court has subject matter jurisdiction, or he wants an explanation for how the court could possibly think that it has subject matter jurisdiction. Let's get real simple about this. Subject matter jurisdiction has to do with a court's ability to hear a type of claim. If that sounds complicated, it's actually not. Now, you can tease out the fringes of this and it can get pretty rarefied, but here's a real simple construct for you. A bankruptcy court has jurisdiction over bankruptcy subject matter, right? A divorce court has subject matter over, I hear you saying family law cases, and you're correct. Now, in most states, including Wisconsin, these criminal cases are going to be heard in the criminal division of a larger state court system. But that state court system has plenary or general jurisdiction over all types of claims which would arise under state law. And the many other, apparently the 70 other counts that he's been charged with, arise under, it's a criminal violation that arises under state law in every single state. Now, the idea that you would challenge a state court judge over whether or not it has subject matter jurisdiction over a committed in that state is completely ludicrous. Like, the reason you would do that is you would say,
Oh, actually, I killed these people in another state.
well, everyone knows, and I don't want to hide the answer in plain sight, but everyone knows where the Waukesha parade was. Waukesha, Wisconsin? And like most parts of Wisconsin, Waukesha is inside of Wisconsin. So, Darrell Brooks, I give you a 0 for that.
All right, bring the jury out. State has its next witness, I presume, ready to go? Yep. All right. When the jury's brought out, you may call the witness.
Is that verified proof that you have subject matter jurisdiction?
The decision
He
in order
can't let
speaks
it
for
go.
itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe so.
Unequivocally.
There's no verified proof proven yet.
Yeah, it's the same thing.
There's no verified proof if we're in common law or admiralty law.
Oh, no. I'm not, I cannot let that go. I cannot let that go. He just said there's no verified proof if we're in common law or admiralty law. For those of you landlubbers out there who don't know what admiralty law is, let me give you a hint. It's similar to maritime law. Yes, it's the law of the sea. Not sure why he's asking this other than he has no sense, but man, he sure thinks he does. He just keeps saying the catchphrases. He's latched on to these ideas that he thinks he understands, but he doesn't understand. Also, while was illegal at common law, it has also been codified in all 50 states, and in the District of Columbia, there is a statute that says, much like one of the commandments from the Old Testament, thou shalt not kill. So, even though there is common law, and also, I gotta back up, common law and admiralty law, they're not even in conflict. That's like saying we can't have bacon for breakfast because we're having pancakes. You actually can have both. Nevertheless, the thing that he's charged with, and many other crimes, arise under statutes, laws passed by legislative bodies. This is not a common law situation. This is an uncommon idiot situation.
Sir, I believe your answers will be in that decision in order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay, so that wraps up his subject matter debacle. I'm giving him a 0. A goose egg, because he has no idea what he's talking about. He's in circuit court, and under the Wisconsin Constitution, the circuit courts have jurisdiction, subject matter jurisdiction, over criminal charges. Brooks, come on, man.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due
Sir, I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. it was seen.
Look, I pressed pause because I don't know where he's going with this, but like, jail.
Based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So here on the screen in front of my face, you see the text of the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Now, there's a lot to unpack there, but he's actually only making one argument, which says to be confronted with the witnesses against him. Now, he is conflating the state of Wisconsin as his accuser because the style of the case, the name of the case is the state of Wisconsin versus Darrell Brooks. And I think earlier I called him Darrell Brooks. I meant no disrespect. Darrell's a great name. Darrell's a great name. But he's flaming out in the courtroom because he has a right to confront the witnesses against him. He doesn't have a right to some theoretical appearance of a mystical entity called the state of Wisconsin. The state of Wisconsin has accused him of a crime for which he is obviously guilty. 76 crimes. The witnesses have to testify in the courtroom. That's all this means. It means that the witnesses must be present. You can't read a statement prepared by a witness outside of the courtroom and say,
Oh, well, this is the evidence.
where he can't cross-examine him. This really is the right of cross-examination. It's so that a jury doesn't hear evidence that's one-sided, because each party to an action, whether it's a criminal or civil proceeding, should have the right to find out, to test the credibility and the reliability and any potential bias of a witness who is offering testimony. That he has to confront the accuser in the courtroom is so misguided. And not to be crass, but his accusers, some of them have, passed away because of what he did.
Do you even know the state of Wisconsin?
Objection.
Grounds.
Argumentative.
Grounds.
Sustained.
So it will be also fair to state that you are not an injured party in this matter, correct?
Objection asked and answered.
Grounds.
Sustained.
Okay, I've just got into this, but what's happening here is he is asking what I can charitably call stupid questions of the witness. The prosecutor is objecting, and he's just regurgitating grounds. What he doesn't understand is that, at least so far, in each of the examples that I've heard, the prosecutor is already stating the grounds. So I don't know how many of these we're gonna sit through, but when an attorney objects to a question, the opposing attorney, and by that I mean the attorney asking the question, which in this case is Darrell Brooks, because he is acting as an attorney for himself, and to put that in the legalese that lawyers love so well, he is representing himself pro se, which just means Latin, it's just Latin for himself. So technically, he is his own advocate. He is an attorney in this action, although clearly he's not. But the attorney asking the question is entitled to know what the grounds of the objection are so that he or she can argue about whether or not the objection is valid. If the attorney has already offered the grounds, like objection asked and answered, then there's really no reason to say grounds, unless you just want to look stupid. Which, if you want to look stupid, that's a really good way to do it. The unfortunate side effect of that is that you also are annoying.
Are you aware what a plaintiff is?
Objection relevance.
Grounds.
Sustained.
Okay, that's a great example. Objection, relevance, grounds. Well, she just said relevance. So those are the grounds. Now, the judge is having none of this because she's saying sustained in very rapid succession. These questions he's asking They're not appropriate. Actual lawyers, and by that I mean people who are not pro se, just don't ask questions like this because they are simply objectionable every time. She should say objection nonsense, but the prosecutor is being charitable. She's not like me. She's not irritated, or at least if she is irritated, she's keeping it tamped down. But like, I'm already irritated and I wasn't sitting through days or weeks of this nonsense. So I shouldn't have cut it off because the next thing he said was, Judge, what's the grounds for you sustaining that objection? Oh my goodness. The lawyer already said the grounds for the objection. And guess what? The judge does not have to make specific findings of fact or conclusions of law in ruling on objections. The judge is either right or wrong, and you just have to move on. Oy.
To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Those
There
are
you go.
legal determinations.
She agrees with me. She's
that
not
if you
legally
feel there
required
is
to
an
do
error
that.
Later
Nice
on,
work, Judge.
You can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times. In fact, you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection, it's a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So that's why to me they're self-evident. I say sustained and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury.
Yeah, the judge is never going to talk frankly and openly to the parties like this in any case, whether criminal or civil, with the jury in the room. This is like a housekeeping sort of administrative meeting. She's being really nice to Mr. Brooks. The things that he's doing are absurd, they're obstructionist, they're ignorant, but it is a judge's job to be impartial and also, and I've said it here before, to appear impartial. Meaning, if they're going to talk frankly with the parties, they need to do that outside the presence of the jury, which she's clearly doing here. So, nice work there. She's also explaining to him the stupidity behind saying grounds after she's already ruled. Because were she to explain those grounds in front of the jury, it would show the jury that he doesn't know what he's talking about. Like making him look dumb, which obviously in a trial or any sort of serious criminal trial shouldn't go into the jury's calculation of whether someone is guilty or innocent. But like, it's really hard for it not to go into their consideration, because after a while they're going to think like this person either doesn't know what they're talking about or is intentionally trying to manipulate the system, try to game the system to get some sort of advantage in court that they're not supposed to have. So I'm glad she's doing this outside the jury, but man, I mean, she must be so tired of hearing this nonsense from him. Wow.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to answer me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Okay, let me give some context here. If you are familiar at all with criminal rights, you know that you have the right to not incriminate yourself. I hope that I don't have to tell you which amendment it is that says that you don't have to testify in your own defense in a criminal trial, but I will give you a hint about which amendment it is. It's this many. It's the 5th Amendment, right? You don't have to testify against yourself. Now, does it mean that you can't testify in court? No, the 5th Amendment doesn't say you can't testify. It means that you can't be compelled to testify. Well, in this situation, the judge has asked him, it's clear from what they're saying,
Do you want to testify?
and she's saying, if you want to testify, you have to tell me that you understand that you have a right to not testify. And you literally have to say those words out loud. You have to say, I understand that I have a right to not testify. And not merely say them, but the judge has to have a good faith belief that you actually do understand that you have a right to not testify. The judicial system doesn't want you to be tricked into testifying. She has said, sir, if you want to testify, you have to tell me that you understand that you have a right to not testify. He refuses to acknowledge that he understands that he has a right to not testify. Instead, he's saying that he doesn't want to testify. Well, she says, okay, well, you're saying then that you don't want to testify. And he says,
I never said that.
I just don't want to read this thing that says that I have a right to not testify. It's actually a lot simpler than he's making it out to be, but wow, I can't, I don't have a lot of patience for this. I really have a lot of regard for judges who sit through, this is a low light reel. This is just a little bit of it, right? We're just getting a taste of it. This garbage went on for days and days, and the judge is doing a fine job of explaining to him what his rights are and what they are not. I guess let's just jump into the next time that he flames out here.
I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You
with
are
them.
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard.
Okay, I'm going to pause it right here. I will jump back into it, but I want to explain what's going on. His position is that he should be able to tell the jury to disregard the law and do whatever they want. That is not a true statement of the law. So she warned him ahead of time that he didn't have the right to say that. He said, I'm going to do it anyway. Then he stands up, and this is his closing argument. He is doing that. The prosecutor objects and says, misstatement of the law. The judge immediately sustains it. Not only does she sustain it, she strikes it, meaning she will later tell the jury, if I struck something, you're not allowed to consider it. So it's hard to unring the bell. I mean, the jury has heard him make that argument, but the judge is making sure that they know that they should reject it. I want to say parenthetically here that while it is customary and in fact very normal to make objections during witness testimony, such as irrelevant, hearsay, lack of foundation, asked and answered, it is really unusual to make objections during either opening statements or closing arguments. There is a lot of latitude granted by courts when you are making an opening statement, and especially a closing argument, to pretty much say whatever you want to say. Now, not anything that you want to say, but pretty much, you can just kind of argue lots and lots of different things. If you have a bunch of spaghetti and you want to throw it against the wall of justice and see what sticks, the closing argument is the time to do that. However, there are exceptions. And one of the exceptions is trying to mislead the jury. Tell them that they have a right to nullify the law when they don't have that right. So, shout out to the prosecutor for jumping in and saying objection, because they're not allowed to do that. The judge nailed it, and it's going to be up to the jury to understand that when the judge strikes it, that they can't consider that what he said might be true.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law.
The last thing that he said is, I believe that you guys, the jury, should be apprised of all knowledge, not just things that certain people say that you should hear or shouldn't hear. That's not how it works. I've said this a million times, But trials are not about what actually happened. They are about what is provable. Some things can be admitted into evidence and some things cannot. And lawsuits are about admissible evidence. They're not about just everything out there in the world or whatever you can imagine. There are strict rules which provide the framework for what can come in front of a jury. And also, if it's a bench trial, what can come in front of a judge. The idea that you would say in your closing argument that I want you to have all knowledge is complete and utter nonsense. Like, it's idiotic. A jury's job is to evaluate the evidence. The evidence, that limited universe of facts which came into the courtroom and was presented as evidence, not everything else in the world. Merely evidence, and then to apply the law to it, not the non-law. So in his closing argument, he's violated like two very, very, very fundamental aspects of what a trial is. One is he's telling the jury you should reject the law, and the second thing is he's saying you should consider facts that aren't in evidence. If I wanted to tell you how much nonsense that was, I couldn't do it. Because it's off the charts. It's like through the roof. It would literally burn my studio down if I tried to summon all of the necessary energy that I would need to explain to you how stupid that is. It's so dumb. Okay, so that wraps up all 5 of his lowlights from this trial. I am very, very pleased to report that guy is never going to be outside of a prison for the rest of his life. It's not going to happen. Pro tip, don't commit crimes. Second pro tip, don't represent yourself in court. I told you at the beginning of this video that we were going to ascertain whether these lowlights could go to prove the old adage that he who represents himself has a fool for a client, and the answer is a resounding yes! You cannot do it. It's too stupid. And I know you wouldn't do it because you're not a criminal. But if you were, don't represent yourself. Hey, thanks for watching till the end of the video. If you haven't subscribed, please do. If you haven't shared this video with someone else, but you know someone you think would benefit from it, share it with them. It helps me grow the channel. If you like, comment, and subscribe, and that's all I really want you to do. In addition, have a nice day.